Welcome to Lemon Live at 5. We have a phenomenal show for you all this weekend. We've got a fat stack of Supreme Court decisions just a few hours ago, and they have major implications for what is going on in this country. And who better to discuss all of this with than the Melissa Murray. She is the Stokes Professor of Law at NYU Law School, the co-host of the Oh So Smart Strict Scrutiny podcast, an MSNBC contributor, and the New York Times best-selling author. And what's more, she is a former clerk for Supreme Court Justice Sonia Sotomayor. Melissa, my friend, how are you? Welcome. Thanks for joining. Perfect guest to wrap this week up.
Thanks for having me.
I love your gavel/microphone behind you. That's pretty slick. Did you come up with that?
That was not my idea, but I do like it. I like it.
Yeah, it's pretty close to what we have. So listen, Melissa, we're glad that you're here. This is some of the things that we are going to cover today to talk about, because I said there's a lot going on. United States v. Rahimi, right? The major Second Amendment decision today that's coming down. We're also going to talk about several of the other looming cases like Grants Pass, Harrington v. Purdue Pharma, and of course the matter of presidential immunity. And I want to pick Melissa's brain on the state of the court and those infamous recordings of the Alitos, and we're going to wrap things up with a discussion of other legal matters around the country, like Louisiana's attack on the separation of church and state. In case you're not familiar with this, Melissa.
I'm familiar.
That is my home state. I am not happy with my home state. It's actually even shocking and surprising for them in this day and age. So Melissa, let's start off with this. Are you surprised at all that the court ruled the way it did on this Rahimi case? Because I was a little bit surprised given how they ruled on this whole bump stocks case just last week. Yeah. I mean, literally last week, they sided with mass shooters. They turned regular guns, I believe, into machine guns. And now they're saying domestic abusers can't have guns. Can you make it make sense for us?
I sure can, Don. So here's the landscape, right? So Rahimi is a case that is squarely about the scope and substance of the Second Amendment, which says that there is a right to keep and bear arms. So it's about what is the nature of that right and how far can that right be extended, or is it limited in some way? The Cargill case, which is the case about bump stocks, is not squarely a Second Amendment case, although it does have implications for the right to keep and bear arms. Instead, Cargill was about an executive agency, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, and whether or not it had exceeded a statute's limit on its prohibitions of machine guns. So it was a question about agency authority, not necessarily about the scope and substance of the Second Amendment. So in the bump stock case, the court said that the Bureau of Alcohol, Tobacco, and Firearms and Explosives had gone too far and had interpreted improperly a bump stock to be a machine gun. And again, there's lots you might say about that, whether you agree with that conclusion or not, but it's not a Second Amendment case, but obviously it has implications for the Second Amendment. This case, Rahimi, is squarely about the scope and substance of the Second Amendment. And if you'll permit me, we have to go back about 2 years. So on June 23rd, 2022, Justice Clarence Thomas gave himself and the NRA the best birthday gift in the world. Justice Thomas turned 74 on June 23rd of 2022, and the gift that he gave himself was a sweeping new interpretation of the Second Amendment, one that allowed for the carrying in public outside of the home of a firearm, something that had not ever happened in American jurisprudence to date. And he argued that the way to understand and interpret whether gun laws comported with the Second Amendment meant that you had to look at whether the gun law in question had a quote-unquote historical analog, whether the founding fathers would have understood this kind of law to be consistent with the history and tradition of firearm regulation in the United States. When that test was announced, it threw all of the lower courts that were hearing challenges to gun laws into disarray. And so we had cases where there was a challenge to a law that prohibited having a gun at a summer camp, and courts were looking around saying, did James Madison go to summer camp? No, he didn't. He never went to Camp Minnehaha. And so therefore, this doesn't have an historical analog. There's no historical twin. We have to throw it out. In this case, United States versus Rahimi, the court had an opportunity to clarify what it meant by having an historical analog. So in this case, Zaki Rahimi had been ordered to be disarmed because he was found to have committed domestic violence. So he had a domestic violence restraining order against him. And under a federal law, Section 922G, if you have a domestic violence restraining order pending against you, you can be disarmed. It's a crime for you to have a firearm. Zaki Rahimi had a firearm in defiance of this federal law. And when he was convicted under that law, he challenged it on the view that the Bruen case made it possible for him to have a gun because there was no historical analog for a law that prohibited individuals who had domestic violence restraining orders from having a gun. And he's right, because back during the time that the Constitution was being framed, when the Second Amendment was being written, we actually didn't do a lot to criminalize domestic violence, and we didn't do a lot to keep those who were domestic violence abusers from doing that. So he's right. There aren't a lot of historical analogs. The United States intervened in that case and argued that it doesn't have to be an historical twin, like an exact replica of an older law, but rather the law in question today has to merely be in the same spirit of laws that historically have been used to regulate guns. And the court today said that's exactly right. It's not an historical twin, but rather the principle. And historically, we have kept dangerous people from being in possession of firearms.
Yeah. Wow. Well, you know, it's interesting to me, especially for the folks when you think about this particular jury, because they view the Second Amendment as sacrosanct, and it's just sort of, you know, the wild, wild west, no pun intended. I do have to tell you that we are live, I think you're aware of that, and this is our show where we talk to our subscribers, and they like to weigh in, they have questions, whatever, they're already weighing in on you. Pamela Lee says, hello, Melissa.
Hi, Pamela.
We have several folks who are saying, I love watching her on MSNBC, and that you're great. Let's see, MSNBC's Lavender says, is my teddy bear these days. And so they're happy to see you here. Debbie Wilcox says, I love Melissa. I learned so much from watching her on MSNBC. Hamilton says, happy Friday, Don. Tim is in the chat. He's actually my husband. And Melissa, Lemonation. So they will have, Winky Campbell says, hi, Melissa. They may have some questions to you. I love that you explained it that way. And we get more time in this particular venue to be able to talk about these things. I know this may sound like a weird question, but I have to ask you, I'm not an attorney. Is there any sort of correlation or anything to, you know, a domestic violence, someone who's been accused and found guilty of domestic violence, correct? Not having a gun. Similar rules for if you are an illegal drug user. You know where I'm going with this with Hunter Biden, and you can't have a gun.
Yeah.
Discuss, please.
So in an earlier case, actually the first time in many, many years that the court took up a question about what the scope and substance of the Second Amendment did or did not permit, this case was called Heller, DC versus Heller, rather. The court, in a decision written by Justice Scalia, made clear that the Second Amendment is a fundamental right, but it's not unfettered. You can limit it in certain ways. And he noted that historically, we had always kept individuals who are so-called dangerous individuals from being in possession of a gun. And so that's one of the things that the court really looked at today in this decision. And again, I want to just note, this is an 8-1 decision. Justice Thomas wrote the earlier decision that this kind of retrenched from. He was the only person in dissent. So basically, all 8 of his colleagues were like, we're going to roll this back. Clarence is kind of out here on his own. And so he's the only one who dissented here. But the question of Hunter Biden is a really interesting one, because under that sweeping vision of the Second Amendment that Justice Thomas offered in the Bruen case from 2022, you had lots of individuals who were facing gun convictions or had been convicted of gun violations, challenging those convictions and the laws under which they convicted as being incompatible with the Second Amendment as it was identified and discussed in the Bruen case. And Hunter Biden is one of them. One of the questions that he has raised, and that will surely be raised on appeal to his conviction, is that the law under which he has been found guilty, this law about lying when you are seeking a permit for a firearm, that it violates the spirit of the Second Amendment as identified and enunciated in the Bruen case. And I think the real question here is, how much does this case, Rahimi, pull that back and make it harder for individuals to make those challenges going forward? So we'll see.
Oh, wow. So I thought I was reaching, so that wasn't a dumb question.
You should go to law school, Don, and you can pass the LSAT right now.
Thank you. Did you guys hear that? Melissa says that I'm smart. Thank you, Melissa Murray. Contrary to the former president who called me the dumbest man on television, but I digress. And look what's happened to him right now. Okay, so listen, Melissa, we have a whole host of major decisions. By the way, you weren't surprised by this decision, right? Was this?
I was not. I could see this in oral argument. There are a lot of people in the court, including the women on the court, who were just like, wait a minute, like it can't be the case that we're going to allow domestic violence abusers to have guns because James Madison didn't prohibit domestic violence.
Yeah. Make sure you guys hit the thumbs up, hit the like, and sure you subscribe. Thank you very much, Lavender, for your contribution to independent media. We appreciate it. And we're happy to have Melissa Murray on today, breaking down all things legal. The perfect guest, considering what's coming out of the Supreme Court. So we have a host of major decisions that have still not come down. Before we discuss them, though, am I wrong to say that it feels like the court is moving slower than usual? I mean, there's still so many cases to be released. At this rate, they may very well extend releases into July, and I understand that that's very unusual. So what's the logjam? Are they slow walking something here? What's up?
So I will say this, the Supreme Court has a discretionary docket. It doesn't have to every case that's presented to it. So they pick and choose what they want to hear. And over the last couple of years, there's been a real reduction in the number of cases that they're taking. So their docket is smaller than it used to be. And yet, it takes the same amount of time, if not longer. During the pandemic, they went into July, and that was likely because we were all at home. No one was going anywhere. Usually, they try to get out by June 30th because they are going, as we've learned from ProPublica and the New York Times, to Italy and Spain and all of these other places, or on billionaire junkets or whatnot. But they've got places to go. And I think they still have places to go now. But I think one of the things and one of the conclusions we can draw from this languid pace that they've established for this term is that there's a lot of infighting at this court. And we saw that today in the Rahimi case. This was nominally an 8-1 decision, which would suggest consensus. But there were 3 concurrences, a dissent from Justice Thomas. This is a group of people that even when they agree, there are real disagreements, and working those out takes a lot of time. So I'm not surprised that we're likely going into July. I don't love it. I was hoping to be off this beat by July 2nd, but I think I'm going to be in the saddle well into July 4th.
Yeah, happy 4th of July to you. Early 4th of July. There'll be some fireworks.
What is the 4th of July to a slave, Don? I don't know. I'm a slave to this beat. Let me be clear. Like, I'm here until they're done.
I mean, come on. We're 2 days after Juneteenth, Melissa. You know.
I mean, Frederick Douglass, it's an actual quote.
So, Melissa, on the topic of slow walking, let's talk about presidential immunity, because you know that's what I'm talking about. Special Counsel Jack Smith, way back in December, I want you,
Sure.
He said, didn't he say, please take up and fast track this matter? But they have dragged their feet at every opportunity. What's up? What's really going on here? Be honest.
Let's lay out the tape. Okay, so one, Jack Smith did ask the court to skip the intermediate appellate court stage and just get this case decided all the way back in December. And the court was like, no, let's let the D.C. Circuit weigh in. The D.C. Circuit, for its part, heard oral arguments on January 9th, but took like a month to decide that case. Like, again, a very languid pace, but they wrote a real banger of a decision. Very comprehensive. They took every argument that Donald Trump made, even the dumb ones, and they gave it the consideration it probably didn't need. And they wrote a very thorough opinion. And I think they wrote a thorough opinion thinking that the court could summarily affirm it and this case would be on its way. The court got that appeal in February, and instead of just summarily affirming the D.C. Circuit or doing something very quick and expeditious, they slated this case for oral argument on April 25th, the absolute last day of argument for the entire term, and we've been waiting since April 25th to find out what they are going to do. Justice Gorsuch at oral argument said that they were likely to write an opinion for the ages, which suggests that, maybe they're taking their time really sweating the details here. But I just want to emphasize that some of the arguments that Donald Trump made here are specious to the point of being stupid. And those could actually be dispatched relatively quickly. And some of the broader hypothetical questions, the court doesn't actually have to get into. And in fact, in a number of cases this term, the court has declined to reach issues that weren't squarely before it, saying, we'll put that off for another day. They could do that here too and render a decision. Why might they be unwilling to do so? Well, there are lots of theories. I have noted on MSNBC and elsewhere that there are two justices here, Justice Thomas and Justice Alito, who are septuagenarians. They don't want to retire under Joe Biden. They do want to retire under a Donald Trump presidency because they know that if they do retire under Donald Trump, they will be replaced by younger movement conservatives. And this court's 6-3 conservative supermajority will endure for another generation and a half. And so I don't know if that's the reason why you're doing it. I'm just putting out facts, right? So that's what's one of the things that may be going on here. It could be that they're fighting over this, but again, they've moved quickly in other circumstances where they've wanted to. So for example, at the end of 2020, when the Biden administration was preparing to take office and Joe Biden had announced that he was going to put a moratorium on the federal death penalty, this court moved with a quickness to decide a whole bunch of pending federal execution cases because they wanted to get to that issue before the Biden moratorium would go into effect. So when they want to, they can move fast. And in fact, historically, this court in the Nixon tapes case that came out right before Watergate moved at about a month. They got that decided within a month, and Richard Nixon resigned by the end of the summer. One of the things you have to remember here is that whatever the decision, this court in delaying the decision on immunity has effectively immunized Donald Trump in any event, because we're unlikely to see that case go to trial.
So the whole immunity thing is moot right now because...
It's not moot. I mean, it's a decision that I will teach in constitutional law next year, and I'll probably learn some things that we hadn't ever known about presidential immunity because we never had a president who'd been charged with crimes before.
Right.
So it'll be new, and I'll teach it to my students. But as a practical matter, I don't think Donald Trump is going to worry about whether he's immune from this criminal suit because this criminal trial is not happening because we're so late in the game.
Wow.
And that's because of the court.
Wow. Folks are loving your bookshelf. That's what I noticed when I see on MSNBC. I'm like, that bookshelf is real back behind her. Someone said it's God tier, Andy Moore says. So anyways, that means she's really smart, guys. Come on, we're talking about Melissa Murray, I should say. Melissa, what's your podcast? It's called Strict Scrutiny, and how do we get it?
Strict Scrutiny drops every Monday morning. It's on the Crooked Network, but you can get it wherever you get your podcasts, whether that's Apple, podcast app, whatever, Simplecast, it's all there. New episodes every Monday and emergency episodes during this period where the court is a chaos goblin and just releasing things. When it's big, we get on the horn right away and get something into your ear holes.
You're on the Crooked Media Network. Is that the God Save guys, right?
Pod Save, yes.
The Pod Save guys, not God Save, Pod Save guys. Great. Okay, so continuing on with what we're talking about, let's play a clip. This is from our friend, Elie Mystal on MSNBC last night, and I would like your reaction. Watch this, Melissa.
I think it's important for people to understand that in the conservatives' own mind, in the Republican-owned groupthink, they're on their revenge tour. Right? Because from the Republican perspective, the court has been acting like a super legislator in the 60s when it ended segregation, when we had the civil rights era and all that kind of stuff, right? And so they think they have made a false equivalency between treating black people and women as people with let's put the 10 Commandments back into scoot, like it's that kind of topsy-turvy thing, but they think that they are getting their revenge on the 1960s and 1970s. They're wrong, but one of the reasons why they're wrong is because this idea that the Warren Court kind of superseded elected majorities in the South is kind of wrong when you remember that the 1964 Civil Rights Act and the 1965 Voting Rights Act were broadly popular. And pass through the democratic process, not the Supreme Court process. That's the part of the story that Republicans always seem to forget. If they could pass a law banning abortion, if they could pass a law allowing anybody and their mother to own guns, I'd like to see them try. They would lose elections. But because they would lose elections that way, That's why they've gone to their conservative buddies at the Supreme Court.
Wow. What do you think of Ellie's argument?
Well, Ellie was our co-host at the Strict Scrutiny live show at the Tribeca Film Festival, so this is not new to me, but I think he's exactly right. I think you have to understand the court is, by its very nature, a minoritarian institution, and the Republicans, the conservatives, understand that their domestic agenda is not one that can be successfully prosecuted in politics. Most Americans, wherever they are in the country, red states or blue states, actually believe that women should not be allowed to bleed out in parking lots because they're miscarrying and abortion is prohibited. They think that individuals should make decisions about their own bodies with limited government intervention. The Republicans know that if they were to do these things outside of our distorted democratic landscape, they would not be successful. So we've seen them time and time again pivot from the political process to the courts as a means of prosecuting their domestic goals. So, for example, with Obamacare was wildly popular, but Donald Trump wanted to repeal it, and he indeed ran on repealing Obamacare. But when push came to shove and it came to Congress, John McCain famously voted thumbs down. So what did the Republicans do? They didn't pack up their camp and say, you're right, people like it, we're done. They headed to a district court in Texas and they filed a challenge there against Obamacare. And it wound up gumming up the works for about 3 years before the Supreme Court finally put the kibosh on it and said, we're keeping Obamacare. But I mean, that's the kind of thing that we're talking about. Things you couldn't do in ordinary politics, you can do through the courts. And you can do it now, especially because Donald Trump, more than anything, was successful at stocking the lower federal courts with young movement conservatives who are true believers.
Well, listen, I want to discuss some of the other decisions that we expect to come down hopefully sometime next week. My viewers know that I'm particularly interested in this Grants Pass v. Gloria Johnson. I've spoken to both Michael Learoff from the 5-4 podcast, Nina Turner, about it, and they both agree that this case could functionally criminalize homelessness. This is a clip from a documentary about the case, and then I'd love your response. Roll it.
It's moving day. What does that mean?
That means we go to another car.
That's all we do is we go back and forth.
You think your rib's broken? Many of these people have done everything they can. They're on a waiting list. They have HUD vouchers. Forcing people to move solves nothing.
I am back in Grants Pass. If you are not aware, it's even hard to just explain how this is just like the most insane response to homelessness I've ever experienced in my 15 years traveling around visiting cities and homeless people. Every 3 to 5 days, homeless people have to move to a new park. The parks are filled with tents. There is one gospel rescue mission, but if you're disabled or if you don't want to sit through 2 Bible studies a day, then it's not a place for you. So the city's response is just musical parks, pushing people from park to park. So today I'm with a bunch of medical professionals and volunteers that are helping homeless people move their tents to a new park. It's moving day. What does that mean?
Look, this is a real dilemma.
Yeah.
Can you explain, please, to our audience why Grants Pass is such a big deal? At least I think it is.
I think it's an enormous deal, both as a humanitarian problem, and I say that as someone who lived for 12 years in the Bay Area where homelessness is a real issue. Homeless encampments are a real issue, not just for those who are unhoused and who sometimes are forced to live in really unsafe conditions, but also for everyone else in the community who want safe, affordable public housing. Like it's just, we're at a moment where the need for affordable housing is so great, and yet the availability of it is really, really limited. And it's the perfect storm. So I totally understand both sides of this issue. I actually think in this case, it would have been really interesting in terms of the court's composition to actually have a justice from the far west, Washington, Oregon, California, where these issues are really, really pronounced. Most of these justices are very much beltway types, with the exception of Justice Gorsuch, who's from Colorado. But this is a real issue in the West, and it would be interesting to see how someone would take that on. At oral argument, they pressed, I think, the real question here. Can cities, in trying to address their problems with unhousedness, can they go so far as to target the homeless, to drive them out, to exile them to other communities? Can they make it a crime to be homeless? And the cities argue that we're not criminalizing the status of homelessness. That would be unconstitutional per this case called Robinson, which was decided in the 1960s, that says you can criminalize conduct, but you can't criminalize a status. So while you can make it a crime for someone to drive under the influence of alcohol, you cannot criminalize being an alcoholic. Well, the city says we're not criminalizing being homeless. We're criminalizing camping out in public spaces and with bedding. But if you're anyone with literacy and, cognitively together, you'll know that the only people who are camping out are people who don't have homes. So it is nominally a law that criminalizes camping, but it's a law that criminalizes camping in the context of trying to address this population of unhoused people. And one of the things that was really striking at oral argument is the kind of empathy gap on the court. I think some of the justices very much understood that this is a heart-wrenching problem, but there were others who were just sort of like, what to see here? What about the residents and their home values and things like that? So I think this is going to shake out in ways that I think mirror some of the conversations that we have in our political discourse about what is really a trenchant and embedded problem.
Well, this is why, elections are so important. I mean, people think, I don't really like either of the candidates. I'm not inspired. I'm not motivated. But whoever sits in the White House gets to choose, right, the justices that affect the trajectory of your life, right, moving forward.
Don, can I just say, as a Black woman, when has any person of color loved everything about any candidate? You're always picking and choosing, sort of accommodating certain things that you don't like, and because you are thinking about the greater good, the greater collective interest. We're all making trade-offs. We don't live single issue lives. Do I love everything that the Biden administration has done? No. Do I think on balance that it will be better for me, people like me, for my children, if it's a Biden administration as opposed to something else? 100%, which is why I will take myself to the polls. And Black people have been doing that for generations. I don't love everything about this, but I'm going to do it because I believe in the greater good. And I believe that this is a right that people literally died to exercise.
Well, I mean, look, even with the Obama, who's a Black president, right? The second term, people were like, I wish he had done, why isn't he doing, enough for Black people?
Well, it's the Janet Jackson effect. What has he done for me lately?
But still, they went to the polls.
They did.
And they voted. And so you got to do the same thing. Of all the cases, Melissa, that are coming forward, what do you think is the one that's the most consequential to be decided? And other than presidential immunity, is it the Chevron deference? Is it Grants Pass? Is it Purdue Pharma? What is it? Or is it something else?
I think it's the Chevron deference cases. Not to take no shade to any of the other cases. They're all hugely consequential. I mean, I think the Purdue Pharma bankruptcy settlement question is going to be a question about whether or not those communities that have been absolutely ravaged by the opioid epidemic get the funds that they need to address that problem. I think that immunity obviously has huge consequences. Grants Pass has huge consequences for how we live. But most people do not understand that every day they are connecting with government through the administrative state. You want to get a passport? You go to an administrative agency and you get your passport. Your mail is part of an administration.
I did that this morning, by the way, the passport.
That's how we get our connection to government, through administrative agencies. The way the administrative state works is that Congress passes laws, and they're sometimes written really broadly, and because Congress people don't have particular expertise in certain areas, they delegate the administration of that law to the administrative agency, like the EPA, for example. So instead of having Marjorie Taylor Greene decide what levels of particulate matter should be in the air, we delegate that to the EPA and scientists and experts who make those decisions based on evidence-based science. And this question, in this case, Relentless and Loper Bright versus the Secretary of Commerce, is whether or not, in circumstances where a statute may be ambiguous about how it should be executed, whether we defer to the agency with expertise to make decisions about how to interpret the statute, or whether we give that choice to the courts to decide. And the courts say, Congress should just write better statutes. Of course, Congress should write better statutes, but they're not scientists. They're congressmen and women, and they write statutes and they give it over to agencies. It would be much harder for things to happen if courts were making those decisions. So think about the Occupational Safety and Health Administration deciding, what's a safe workplace for us to work in? Do we want that to be decided by some random judge in Amarillo, Texas, or would we prefer to have that decided by people who are actual experts in how workplaces should be organized and run? I mean, it's a real question. Honestly, I think it comes down to the MAGAification of America. Are we going to trust expertise, or are we going to trust people who just speak really loudly into microphones on the political stage?
The MAGAification of America. I love that term. I don't know if I've ever heard that. It's true, though. We are living in that. I mean, look.
It's like Dr. Fauci. Are you going to trust Dr. Fauci, or are you going to trust Marjorie Taylor Greene? I know where I am.
Well, she knows a lot about Jewish space lasers, but go on.
What else is there to say, Don?
Well, we could say bleach blonde, but I'm not going to go there. Okay. I'm going to take a pivot. Not really a pivot. This is like a little bit of a zig instead of a zag, or a jog, maybe. Ever so slightly here. And I'm going to talk about the state of the court today, because as I mentioned at the top of the show, that you clerked for Justice Sonia Sotomayor, and recently she told an audience, this has me a bit worried, this is at Harvard University, that she sometimes cries after the court hands down its decisions. She suggested that she cried a lot, even just during this term. So, you know her well. How do you think she's doing? And do you think that those remarks were a warning regarding some of the decisions to come?
Well, I should disclose, one, I clerked for her when she was a judge on the Second Circuit, which is the intermediate appellate court in New York. So I don't want to overstate my credentials here. But I was her clerk, and I was there at the Radcliffe Institute where she made those remarks. She was receiving the Radcliffe Medal, and I was there with my daughter to see her receive it, was part of the program. And when she made that statement, in that tent of probably 500 people, there was an audible gasp, where everyone just kind of had this big intake of breath, because I think people did understand that it wasn't just a statement about how she's done. It's a statement about how she expects to continue working over the next couple of weeks. It was both retrospective and entirely prospective. And I think you can see that. Some of these decisions, the bump stock decision where she dissented and was sort of the majority's reading of the statute is absolutely bonkers. What do you mean bump stocks do not transform semi-automatic rifles into automatic weapons? Do you remember the October 17th shooting in Las Vegas, which is the deadliest shooting to date in the United States? It was done by a single guy in a hotel room in the Mandalay Bay with a bunch of bump stocks.
I was there. I covered it. I wasn't there when it happened, but I covered it, and it was just horrific. And that's when we started learning about bump stocks. Yeah. And that's the reason. It was a Trump administration who sort of put the ban on bump stocks into place, and then now, right?
Yeah.
Now they're saying that they did not have standing.
Well, not that they didn't have standing, but that their interpretation of the statute exceeded the scope of the statute.
Okay. So, what's the difference there? Tell us the difference.
Well, standing is a jurisdictional question, who should be in court. So in the mifepristone case, which was the challenge to the FDA's regulation of mifepristone, the court kicked that out on the ground that the doctors who had argued that they had an aesthetic interest in seeing babies born but had never actually prescribed mifepristone lacked an actual injury and therefore didn't have standing to bring that case.
Yeah. Okay. I'm conflating the two. So many decisions to come out. Melissa, I'm sure by now you've heard the secret recordings of Justice and Mrs. Alito 100 times. I'm sure you've heard of it a million
Vergonia.
times. Oh my gosh. I just want to quickly play one portion of some of this for the audience. This is Mrs. Alito vowing to, quote, get them being the media and her perceived political enemies. Here it is.
I'm a huge fan of your husband, and everything that you're going through, I just want to tell you that, like, it's okay. Yeah, it's okay. It's not okay, though. It's not okay. It's okay. It's okay because if they come back to me, I'll get them. I'm going to be liberated, and I'm going to get them. Oh, well, there's a 5-year defamation statute of limitations.
But I don't know what you mean by they, like
the media. Yeah. Oh, okay. Come on, I'll get you. Come on.
I mean, I know the Supreme Court has always been a political institution, but I mean, what happened to the days of Ruth Bader Ginsburg and Antonin Scalia, like vehemently disagreeing and then going to opera together, after work? It seems that some of these justices and their spouses have become crazy radicalized.
Okay, well, so I think that's true. This is very outspoken for a spouse. I'll call your attention to Sissy Marshall, who is the wife of Thurgood Marshall. He was the first African American to serve on the court. She died last year or 2 years ago, maybe. And she noted that when they moved to Washington, when her husband took up this seat on the court, they had been very gregarious. He had been the director counsel of the NAACP Legal Defense Fund. They socialized all the time. But when he became a justice, they basically became recluses because he knew that he had to be above reproach, that any whiff of scandal would doom the first Black justice. And so they retreated to their families. They weren't out, making statements like this. They weren't talking to undercover reporters. They were being pretty quiet and keeping to themselves. So that's, one thing to note. The second thing I'll say is that this is the MAGAfication of the Supreme Court. Like this sort of vengeance-fueled, I'm coming for them. There's a 5-year statute of limitations on defamation and I'll get them. Like that's the kind of grievance-fueled narrative that is animating Donald Trump's current run for the White House. It is animating Project 2025. And if your listeners or viewers don't know about Project 25, get hip to that because it's 900 pages of absolutely crazy stuff about what the new Trump administration, if they are elected in November 2024, what they will do in the first 180 days. And most of it is retaliating against their enemies in government, in the media, everywhere. So this doesn't surprise me. It is saddening, though, because it does, I think, reflect, at least on the spouse level, the MAGAfication of the court.
I wonder, I know you're not a psychiatrist or a psychologist, but I mean, what makes people think that they can, especially if your husband is a Supreme Court justice, like what makes you think it's okay to act that way? You can, even in certain positions, like when I was in traditional news, I wouldn't say, well, I'm going to vote for Joe Biden. Like, you knew, like, okay, you just don't go there. What makes them think that that's okay?
So there are very few limits on the court, which means that the justices are relatively unfettered in what they do. And we've seen that over the last 2 months as more and more evidence comes out about gifts that aren't properly disclosed, about some of the justices having an emotional support billionaire. All of that is because there are very few checks. Like Congress can't do anything. We don't have a supermajority in the Senate, so impeaching Clarence Thomas for the failure to disclose these billionaire gifts is not a possibility. Impeachment is very much a paper tiger. The Congress doesn't seem to want to draft legislation that might rein in the court or strip it of jurisdiction in certain cases. So they have a supermajority. They have 6 conservative justices. They don't need the Chief Justice ever, so they can be as conservative as they want to be. And there's no one to check them. The only check that really exists is us exercising our desire to see something different when we go to the ballot box. But other than that, there's nothing really stopping them. They're basically like Sheree from The Real Housewives of Atlanta. Who gonna check me, boo?
No, you didn't.
I did.
And who's got the white refrigerator?
honey.
A white refrigerator.
Kendra had a white refrigerator.
I know, and I'm just saying which one of the wives has a
mean,
white refrigerator. I think it would be Mrs. Alito who would have the white refrigerator. I don't know.
She seems very traditional.
Can we talk? Because folks are all up in the chat. When you brought up Project 2025, people just go nuts on that. Bunny Scoggins says Don needs to do a show geared discussing Project 2025. We're going to do that, and so much more, especially leading up to the election. Trust me, we're gonna get there. It's been in the questions, but we haven't had one show just dedicated to it. No, ma'am. I love that name. Says Project 25, ready to discuss. Corruption is legal for U.S. justices, says B.A. Ware. Let's see. They are protected from accountability, says Lavender. Do you agree with that?
I mean, I basically just said, that's what I said. Like, there are very few checks on this court, like actual toothy checks. Like, they passed a code of conduct where they actually watered down the kind of ethical standards that they're supposed to adhere to. Like, before, the code used to read that the justices shall do something, which suggested that there was something mandatory that they were required to do. Now they've changed that, so they should recuse themselves in certain cases, which makes it entirely discretionary and up to them. And again, neither Justice Alito nor Justice Thomas is recusing themselves from anything of consequence.
I thank you very much for supporting independent media. Soldier, again, thank you. Melissa has such thoughtful commentary. I just subbed to Strict Scrutiny.
All right, thank you.
Lemonheads, go follow her. Amen. I agree. Go follow her on Strict Scrutiny. Hit the thumbs up over there as well. Here's a good question for you. Can they do, who was it? Someone says, can they actually do what is in Project 2025?
Oh, 100%. 100%. Project 2025 is so diabolical.
Debbie Wilcox, by the way, is who said it. Go on.
Debbie, it's an excellent question. It is utterly diabolical because Project 2025 doesn't rely on Congress. Like, you don't need a Republican majority in Congress to do any of this. All it relies on is putting the right people in administrative agencies like the Department of Justice, for example, and then letting those movement loyalists do their work. So, for example, if you're concerned about reproductive rights and you're worried that the next election, whoever comes in, there will be an opportunity to pass a nationwide ban on abortion, especially if they get both houses of Congress, they don't actually need both houses of Congress because there's a law from 1873 called the Comstock Act. It was passed in 1873 by a guy named Anthony Comstock who led the charge, and it prohibits the distribution in the mails of any article that might be used for quote unquote immoral purposes. And that includes any medication abortion pills, could include certain forms of long-acting contraception, and they don't actually need Congress to enact a ban on abortion. All they need to do is get a new AG in a newly reconstituted Department of Justice who's willing and ready to enforce the Comstock Act, to revive that zombie law, and they can just ban abortion by basically enforcing the Comstock Act against us, and there's nothing we can do about it. So, I mean, that's another reason to think about the polls and whether you are a single issue voter or a multiple issue voter.
Wow. Okay. Can we talk about my home state, Melissa?
Yes, Louisiana, yeah.
Oh my God. I would love to get your thoughts on what's going on. This new 10 Commandments law out of Louisiana. I mean, we have some sound. This is the governor signing it yesterday. But watch, someone passes out, a little girl. There's a whole lot of mess going on.
Some mess going on in the back.
Yeah. Right. Go ahead and roll it.
This bill mandates the display of the 10 Commandments in every classroom in public, elementary, secondary, and post-education schools in the state of Louisiana. Because if you want to respect the rule of law, you got to start from the original lawgiver, which was Moses. All right. That's right. He got his commandments from God. For us. All right.
Okay, this is.
I was like, honestly, as a mother, I'm just like, Did he not understand that a child literally fell
I don't
out
think they
behind
saw
him,
it.
right
Did-
behind him?
did you-
I know, but like moms have these sixth senses. Like, I mean, like if my kid was behind me and fainting, I
You
would know.
You would know.
Even if I was signing an absolutely bonkers law that is patently unconstitutional, I would know that something was going on.
Andy, roll it again, but not with the volume. We just want to see it as Melissa's talking about it. But what were you saying?
I think I would know if this were happening behind me. Like if a child, like I don't know, just like being a sentient human, you'd notice that there was some commotion behind you.
Well, it kind of sums up, again, if we roll it, if you can roll it without the sound, it kind of sums up just how oblivious they are of
Can't
what
roll
is
without
actually.
sound.
You can't roll it without sound. Okay, well let's
Don,
watch it again. Go ahead.
Okay, we're gonna watch it again.
No, you can talk. You can talk. Well, we're gonna watch it.
The display of the Ten Commandments.
She's bored because she knows this is unconstitutional.
Go ahead with the commentary, Melissa.
She's not clapping. She's like, whatever. And now she's falling out. Here she goes.
Because if you want to respect the rule of law, you got to start from the original law.
And no one stopped.
Which was Moses.
Oh my God.
They're like so ready to sign this law that they don't even know what's happening. Like they can't even look behind them. It's just like bonkers. All right, so what's going on here, Don, in the state of Louisiana with Governor Landry here? I'm gonna have to take you back a minute. So 2 days after the court overruled Roe versus Wade in Dobbs back in 2022, the next Monday, they announced another case called Kennedy versus Bremerton School District. This was the praying coach case. So this was the coach who was employed by the public school system, and during high school football games on the public field owned by the public school, he would pray at midfield with his players. And, you know, some people were like, it feels a little bit like the school board's endorsing Christianity by allowing him to do this. And the school board's like, please stop. And he wouldn't. Anyway, the court cited for him in that case, said that, you know, he had a First Amendment right to be able to do this. And they noted that an earlier First Amendment precedent, which is the test for determining when a government action entangles religion with government activity too much. It's called the Lemon test. The court said that everybody knew that the Lemon test had basically been abandoned. What the court didn't say was that the ones who had put the Lemon test in a drop box and left it was the court itself. So the court hasn't been enforcing or relying on or citing Lemon, and so for that reason, it has been abandoned. Lemon versus Kurtzman would be the precedent among many that would apply to this law that Louisiana has passed. It would be used to determine whether or not, as many have charged, this law improperly entangles the government, the public school system in Louisiana, with the establishment of a particular religion, here Christianity. And under that Lemon test, this would be found patently unconstitutional. The reason why Governor Landry signed that law and why the Louisiana legislature put it before him is because they are understanding that this Supreme Court is very receptive to claims of religious liberty, and in particular, those brought by Christian evangelicals. And they want to present the court with an opportunity to not just abandon Lemon, but to put the stake in the heart of Lemon and kill it once and for all. So this is basically a run on the Establishment Clause, which provides that Congress shall not establish any religion, and nor shall any state establish any official religion. It's because we live in a plural democracy where not everyone is Christian. And this was one of the things that Lauren Windsor talked with Justice Alito and the Chief Justice about in those surreptitious conversations. But it's a real question, and this law makes it a real public policy issue. Are we going to be an ethno-theocratic state, or are we going to be the pluralistic democracy that the framers envisioned?
What do you think would happen if someone petitioned in a public school to have, you know, a verse from the Quran?
I mean, hello.
But I mean,
like if we'd say the original lawgiver was Muhammad, yeah, like that would never happen. It would just absolutely never happen.
But doesn't that make the case for this? Isn't it open? Is there some precedent
again,
here?
like this is such a stupid law, and the arguments for it are so dumb. They're patently unconstitutional. Everyone knows that. This law has been passed, and now a challenge has been brought to it because they want to go to the court. They want this court to overrule Lemon. They want this court to change the jurisprudence. And, make no mistake about it, this Supreme Court has moved so far to the right. Like, lots of people talk about, well, sometimes they let us have mifepristone and sometimes they throw things outstanding. But even when they do things like that, they're still moving the jurisprudence to the right, and they know it and they can do it. The only thing that moderates them is their own sense of what they can get away with at any given point.
Well, I don't know what's going to happen. I have no idea what's going to happen. I do have to tell you, though, I love seeing your doggy in the background.
He's under there.
I know,
right?
my dog was under the desk, or I don't know where he is. He's somewhere around here, but we are a very dog-friendly show. What's your dog's name?
His name is Cole. Cole?
How's Cole feeling? Where's Gus Gus? Gus Gus is here somewhere.
What kind of dog do you have?
I don't know.
We'll bring him in.
It's a poodle of some sort.
A mix.
We don't know. It's a mix because we have 3 shelter dogs. And so everyone said, didn't you do the DNA? And I'm like, no, because I don't care what they are. They're mine. I love them.
Well, he's a
Gus
beach
Gus
too.
is being transported to the studio.
He's what?
Gus Gus is being transported to the
How did you hear that? Gus Gus has an ear infection, so I brought Gus Gus in the office today in a backpack on my city bike. And there he
he's
is.
so
Thank you. He's still got part of his collar on. Gus Gus, say hi. Isn't he cutie?
Come here.
Where is he?
Here he comes. Come here, baby.
Gus Gus, say hi.
He's stretching now.
Is he?
Yeah, come on.
What is it? What's his name again?
Cole.
Cole.
Yeah.
Cole, meet Gussie.
Oh. Hey, Cole. Can you say hi?
Cole, what do you think about what's happening with the Supreme Court and the election? Can you weigh in? Who's going to win the debate?
Hard to say.
Are you worried about this debate?
I mean, again, of course, anything could go wrong. Who knows?
Uh-oh, he killed your microphone. Cole, what are you doing, Cole? Oh, there you are. You're back.
Anything could happen. I'm looking forward to it. I hope it'll be substantive, but I think given one of the candidates, it's very unlikely to be substantive. It's going to be very performative.
Yeah. Do you think it's going to make a big difference on?
Maybe at the margins. Again, I think you have to realize with our system, this election is going to be decided in a handful of states that are really, really close. And so, yeah, at the margins, anything might make a difference. Whether some people are like, it's a bridge too far to me to vote for a convicted felon, that might make a difference. I don't know. But that's the reality of our system. That's a whole separate conversation about all of the ways in which our system is already distorted in terms of its democratic potential, because we essentially allow the whole election to be decided by 5 different states.
Thunderbird says, because Cole knocked your mic off, that Cole is MAGA.
He is not. He is not. He is not MAGA.
He's not MAGA.
He's not. He's the best.
So, Melissa, let's end really on a happy note, if we can, because we have our dogs in here, and hopefully, it'll end up positive, the debate and everything. How was your Juneteenth?
It was great. I had a good time. I wound up having to come in the office to do some things, but mostly hung out, and it was great. I love this new Juneteenth, right? Like a new holiday, and we're really sort of focused on the history, especially at a time when so many states are avowed in their attempts to keep people from knowing this history. I'm glad that Juneteenth exists for that purpose.
Yeah. Well, I'm going to let you go. You and Cole go. Your MAGA doggy.
It's not. Don't say that.
Kidding.
No,
kidding.
no.
Say bye. By the way, has Cole ever had an ear thing?
Oh yes.
Do you know the ear medicine?
No.
It's smelly.
It is smelly. Yeah, it is a little smelly.
Yeah.
So, sorry, Dawn.
Yeah, I know. Thank you.
All
You have a
right.
great
Thanks
weekend.
for having me.
I watch you on MSNBC. We'll have you back, and it's
Okay.
called Strictly Scrutiny. It's on.
No, it's called strict scrutiny.
I'm sorry, Strict Scrutiny. Excuse me, Strict Scrutiny, and it's on the Crooked Media Network with the Pod Save America folks. And so make sure you like and subscribe. It comes out every Monday morning. You said.
Every Monday morning.
Okay.
All right. Thanks,
Thank you.
Don.
You be
Okay.
well. No, you hang up. No, you hang up. I tell that every day.
All right.
So, guys, it's been a great week. We're so happy that you've been able to join us this week. Make sure you hit the thumbs up. Make sure you hit the like. Again, I know that it's a summer doldrums, and a lot of people are dialed out, but we're going to still build the community. We're still building. And Gus is here. Boomer and Barkley are at home. Gus wasn't feeling well. I didn't want to leave him at home by himself because I worry about him. So make sure you pre-order my book, okay? There is a link. If you look, I think it's in the bio somewhere or on the community page, but I will put another link somewhere if I can find it. I'll put another link in the chat, but make sure you go and pre-order the book. It's called I Once Was Lost, My Search for God in America, okay? And it comes out in September, but if you pre-order now, it'll help the algorithm, as they say, okay? So everyone, have a great Friday evening. I hope you enjoy yourselves. Be safe out there. Don't drink and drive, but, have a cocktail or two if you're gonna be, doing a ride share or at home. And have a great weekend. I may see, there it is. It's in the chat, okay? Click on that link in the chat and go pre-order the book. Andy Moore says, peace out, Don Lemon. Feel better, Gus. Yes, I'm going to go home. I couldn't bathe him because he's got the ear stuff for a little while, and the vet said, don't bathe him, put the ear stuff in there, let it take effect, and then I'm going to get the stinky smell out once it's over, okay? So everybody, I'll see you maybe this weekend. I'm not so sure. I'm going to be traveling, but I'll see you soon, okay? Have a good one. Bye. Say bye, Gus. Bye. Bye.